To thoroughly understand the inner workings of the situation at hand, you must first be able to separate business from friendship. If you are emotionally attached to any of the said people in this video, you will more than likely overlook the facts. A common practice used by law enforcement is good cop, bad cop. Good cop, bad cop is a psychological tactic used in interrogation and negotiation, in which a team of two people take opposing approaches to the subject. One person adopts a hostile, accusatory demeanor, emphasizing threats of punishment, while the other person adopts a more sympathetic demeanor, emphasizing reward in order to convince the subject to cooperate. This tactic is also commonplace in the entertainment industry, specifically the music business. It doesn't take a rocket scientist to figure out that this is what allegedly goes on at Cash Money Records, with Slim being the good cop and Baby being the bad cop. Since the inception of Cash Money Records, Brian Williams, aka Baby, has always stated Sugar Slim is the Don of Cash Money. Slim makes all the decisions and calls all the shots. According to Who You Ask, Dwayne Carter, aka Lil Wayne, is the most influential hip-hop artist of his generation, running with his self-proclaimed title, Best Rapper Alive. Wayne's rap career will begin in 1995 when he will start appearing on songs for Cash Money Records. Wayne will be the youngest member of the label. Contrary to popular belief, Wayne didn't actually sign a contract with CMR until 1998 per federal court documents. The court docs read as such: on November 1st of 1998, Dwayne Carter and Cash Money entered into a written recording agreement pursuant to which Carter agreed, amongst other things, to provide exclusive recording services to Cash Money per the 1998 recording agreement. Pursuant to the 1998 recording agreement, Cash Money agreed to, amongst other things, to render accountings and pay royalties to Carter on or before every 30th of September with respect to semi-annual period ending every June 30th, and on or before every March 31st, semi-annual period ending every December 31st, in respect of sales by Cash Money of recordings delivered by Carter thereunder. The 1998 recording agreement contains various provisions relating to royalties and advances payable to Carter, product delivery obligations, and Carter's rights of audit and option periods to extend the terms thereof. Link to the federal court docs, which are public info, is pinned in the comments. The publicly shared drama and dispute over the Carter Five wouldn't be the first time that Wayne would drag Cash Money to court over his bread. In 2005, Ron Sweeney will represent Wayne in court regarding contractual obligations that were not being honored by CMR. Lil Wayne would win the settlement. The court docs read as such: the 2005 settlement agreement amended the 1998 recording agreement by, amongst other things, extending the number of options period during which Carter would be obligated to provide recordings embodying his individual recorded performances to Cash Money Records, fixing recording costs and amending royalty rates payable to Carter. The terms of the 1998 recording agreement, not expressly amended by the 2005 settlement agreement, remain in full force and effect. The 2005 settlement agreement also amended the 2003 Young Money Labels agreement by, amongst other things, extending the term thereof, amending the Young Money label service fee, and providing Carter with an advance against profits earned by the Young Money label. This would be another big win for Weezy. Let's move on. In 2003, Wayne would enter a label deal for his own imprint, Young Money Entertainment, partnering with CMR. Contrary to popular belief, CMR was not the sole owner, operator, nor the distributor of Young Money Entertainment. For a 51-49 split of profits in favor of Lil Wayne, CMR would promote the label, while Universal would act as the manufacturer and distributor. The court docs read as such: on or about February the 20th of 2003, Carter and Cash Money entered into a self-styled memorandum of agreement, the 2003 label agreement, for the creation of the Young Money label joint venture for the common purpose of the manufacture, distribution, promotion, and exploitation of recordings containing the performances of new recording artists who will be signed to the Young Money label, following approval by Carter, the sole owner of the joint venture. The 2003 label agreement provided that, amongst other things, after the deduction of a distribution fee and cost, the profits of the Young Money label will be divided 51-49 between Cash Money and Carter, and ownership of all the Young Money label property, company, recordings, copyright, intellectual property would be owned 51-49 between Cash Money and Carter, respectively. The 2003 label agreement also provided that the Young Money label would use the same manufacturer and same distributor, Universal Music Group, Inc., that Cash Money uses for its own recordings. Cash Money and Carter agreed that the Young Money label would be charged the same net distribution fee by Universal in respect of the Young Money label recordings as Cash Money was charged by Universal for Cash Money's own recordings. If any portion of this agreement is broken, Carter has the right to file for breach of contract, during which he will obtain the sole access of Young Money Entertainment, dissolving CMR from the agreement. In other words, I'm dipping with all of my artists if you played with my bread. Put your AirPods in and pull up a seat and grab your popcorn. This is about to be a long one. For approximately 4 years, numerous issues and disputes could arise between Cash Money and Weezy as a solo recording artist, and with respect to Weezy's and or Young Money's interest in the Young Money label. The court docs would read as such. Beginning in 2013, Cash Money failed to provide proper monthly accounting to Carter and or Young Money LLC as required for the Young Money label, and failed to make timely accounting and or payments of net profits due to Carter and or Young Money pursuant the 2003 label agreement as amended. In addition, Cash Money failed to make the required overhead payments of $200,000 per calendar quarter to the Young Money label, and also failed to maintain the escrow account funded with $1 million for overhead payments for the Young Money label. With regard to the 2009 Drake agreement, Cash Money since 2012 has failed to report to Young Money on a monthly basis and would fail to pay monies owed. Young Money's share net of receipts with regard to the solo recordings of Drake's release by Young Money label were not honored by CMR. Cash Money has failed to provide a single accounting record in the respect of the exploitation of Drake's recordings, despite Drake being one of the best-selling recording artists in recent years. In summary, Cash Money has failed to properly account for and pay royalties as well as profits to Young Money in respect of the exploitation of recordings owned and commercially exploited by Young Money. Cash Money has also failed to make overhead payments and maintain the escrow funds required by the 2003 label agreement and the amendments thereof. Moreover, while required to obtain approval from Carter and Young Money for marketing expenses greater than $300,000, which Cash Money failed to do, claiming millions of dollars of marketing expenses for the Young Money label. Cash Money also failed to properly register the copyright in the Young Money label recordings as jointly owned by Cash Money and Wayne. Cash Money refused to accept artists submitted by Wayne to join Young Money. Cash Money would also fail to account and pay monies due to various third parties involved with recording artists signed to the Young Money label. Such failures have resulted in legal actions against Young Money and Wayne, causing additional losses for Lil Wayne. Upon information and belief, Cash Money has jeopardized the ability of the Young Money label to properly and successfully conduct business and has improperly committed waste to the assets of the Young Money label. With regard to Carter's contractual relationship with Cash Money as a solo artist signed to the Cash Money label, Cash Money has also failed to properly account to Carter, failing to pay royalties and advances to Carter pursuant to the 1998 recording agreement and the amendments thereof. Despite being obligated to do so as of the date of Carter's complaint, Cash Money has not registered Carter as a co-owner of the sound recordings contained in the album titled I Am Not a Human Being, which was delivered for the fourth option period. Upon information and belief of the 2008 amendment, Cash Money registered the copyright in such sound recordings solely in the name of Cash Money Records, therefore breaching the solo artist contract between Wayne and Cash Money Records. Carter 5 gets even crazier. The official court documents read that in early December of 2014, Wayne would deliver to Cash Money the sound recordings comprising the second of the solo albums titled The Carter 5, provided for by the 2012 amendment. Although obligated to pay Carter $8 million at the commencement of recording of The Carter 5 and $2 million upon delivery of the album, Cash Money breached the 1998 recording agreement as amended specifically by the 2012 amendment by failing to pay Wayne the $8 million payment upon commencement of the recording and paying Wayne only $2 million over the course of the recording of the Carter 5. Moreover, Cash Money has refused to pay Carter the $2 million due upon delivery of the Carter 5. Cash Money has refused to pay Wayne the balance of $8 million due to Wayne in respect of the Carter 5. Cash Money has not provided Wayne with any contracted or statutory basis for failing to pay the balance for the advance for the Carter 5 and has given no assurances that it will not similarly refuse to pay Wayne the $10 million advances due to him for the next two albums as required by the 2012 amendment to the 1998 recording agreement. This is where the rumored $10 million lawsuit settlement figure would come from. After Sweeney's diligent efforts, the courts would agree on behalf of Lil Wayne. Despite of what you may have heard or seen, Lil Wayne is no longer a CMR solo artist, although his image and likeness is still being utilized on Cash Money Records' website. The court judgment reads as such. By virtue of the foregoing, the relationship between Dwayne Carter and Cash Money Records has been damaged. Wherefore, the plaintiff demands judgment against the defendants in each cause of actions as follows. On the first cause of action, a monetary judgment against CMR in an amount to be determined at trial for event less than $8 million with interest at the statutory rate from the date of Cash Money breaches of contract. On the second cause of actions, a mandatory judgment against CMR in an amount to be determined at trial with interest at the statutory rate from the date of Cash Money's breaches. On the third cause of action, a monetary judgment against CMR in an amount to be determined at trial no less than $5 million with interest at the statutory rate from the date of Cash Money's breaches. On the fourth cause of action, a monetary judgment against CMR in an amount to be determined at trial, but in no event less than $13 million with interest at the statutory rate from the date of Cash Money's breaches. On the fifth cause of action, a judgment requiring Cash Money to render accountings to Carter and Carter Young Money Entertainment. On the sixth cause of action, a monetary judgment against CMR in the amount to be determined at trial, but in no event less than $25 million with interest at the statutory rate from the date of Cash Money's breaches. On the seventh cause of action, a declaratory judgment determining that Carter is the joint copyright owner of the recordings delivered for the fourth and fifth option periods of the 1998 recording agreement as amended, that Carter and or Young Money LLC are as a joint copyright owner of all Young Money label recordings. On the eighth cause of action, a monetary judgment against CMR in an amount to be determined at trial with interest at the statutory rate from the date of Cash Money's conversion and granting plaintiffs such as other and further relief the court deems just and proper, including the obligation of Cash Money to pay all attorney fees in cause of action. Birdman would later go on to make a public apology to Lil Wayne during Lil Wayne's Louisiana Fest in New Orleans, Louisiana. In June of 2018, the courts will allow Weezy to terminate his contract with Cash Money Records and to take sole ownership of his Young Money label. Baby would take to the stage at the festival and say the following. I'm paraphrasing, of course. It feels amazing to be home, rocking with my son. I love him to death. I don't know what y'all think y'all know, but I know what the F I know, and I know how I feel about what I know. I knew this day was gonna come, but I ain't know when it was gonna come. But this dude right here, you heard me, is the best little dude, you heard me, the realest dude, the illest dude, and I wanted to apologize to my dude worldwide. This is the reason Wayne won't be a part of the Hot Boys reunion.